Did you know that federal law prohibits discrimination in employment on the basis of genetic information? Do you even know what genetic information means? My name is Scott Horton. I'm a labor and employment attorney in New York State. And I just want to let all employers know that if they have at least 15 employees, then they're covered by the Genetic Information Non-Discrimination Act, or GINA. This law has been in place for several years now, but very few employers recognize the full extent of its protections. First, let's talk about what genetic information means under this law. Genetic information includes an individual's genetic tests, the genetic tests of that individual's family members, the manifestation of disease or disorder in family members of the individual, which is basically their family medical history, an individual's request for or receipt of genetic services or the participation in clinical research that includes genetic services by the individual or a family member of that individual, or the genetic information of a fetus carried by an individual or by a pregnant woman who is a family member of the individual, and the genetic information of any embryo legally held by the individual or family member using an assisted reproductive technology. Wow, so what does that mean? Well, first of all, it means that genetic information does not include any information about the sex or age of the individual or sex or age of family members, or information about the individual's race or ethnicity of either the employee or family members. All of those are actually protected in certain ways by other federal laws, most notably Title VII. But what is very important about GINA is that its references to family members are very broad. It includes a person who is a dependent of the individual in question as a result of marriage, birth, adoption, or placement for adoption, or a first degree, second degree, third degree, or fourth degree relative of any of those individuals, or of a dependent of the individual in question. In other words, family member includes the employee or applicant's parents, siblings, children, grandparents, including great and great grandparents, grandchildren and great great grandchildren, uncles, great uncles, aunts, great aunts, nephews, nieces, first cousins once removed. Wow, a lot of family members. So, putting all of this together, the law says that employers cannot discriminate against employees on the basis of the medical history of any of those broad scope of family members of the employee that you're dealing with. Moreover, the Genetic Information Non-Discrimination Act says that employers generally cannot even acquire genetic information about their employees. That means that if you inadvertently do acquire this information, you need to rely on an exception to the law. An inadvertent acquisition is an exception, but whether you get the information knowingly or accidentally, you as an employer would still have the obligation to maintain confidentiality regarding the employee's genetic information. There's just so much more that this law has to say, but I just wanted to give you this overview so you don't forget that it might be possible that GINA affects your employment decisions.